Good afternoon. Today we have Tom Prettyman here from New Mexico Legal Aid, who is going to talk with us about landlord-tenant law in New Mexico. And before I introduce Tom and turn it over to him, I want to go over a few housekeeping things. So we are a pretty large group. We're doing this as a Zoom call today instead of a webinar, so we have a sense of who is on the call, and you can see that it's a group instead of just seeing the presenters all the time. But we are asking everyone to keep themselves muted, and we are recommending that you use the speaker view. So if you go to the top right corner of your Zoom app, there will be a little icon that you can use to switch from gallery to speaker view. If you're not in speaker view already, you are in speaker view. You should just see a really big picture of me on the screen. And so that way you'll be able to see Tom as he's presenting. And if you have questions, please put them in the chat box, and I will be monitoring that chat as we go through the presentation. And we'll be transmitting your questions to Tom. And so with that, for those of you who didn't hear me at the beginning, my name is Grace Spulak. I am the director of the New Mexico Commission on Access to Justice. And we are doing this series of webinars to get information about important legal issues out to our partners in community organizations across the state. So thank you all for joining us. Huge thanks to Juana Beta, who is working with the Commission on our community engagement work and was really the mastermind behind these webinars and who has done a lot of the organizing, getting the word out. So thank you so much, Juan. And now I'm going to turn it over to Tom Prettyman, who is the managing attorney at New Mexico Legal Aid, the Albuquerque office, where he oversees the housing law practice group. He's a graduate of the College of William and Mary, and he also graduated from Rutgers Camden School of Law. So thank you so much, Tom.
Hi. If you look in your chat box, you'll see that I put in my contact information. So if anybody has a question, they can call or email me, and I'll try to get back to you. And if you don't hear back from me, try it again. I'm not ignoring you. I'm just scatterbrained. So today I wanted to talk about New Mexico landlord-tenant law, and hopefully this will help you when you're dealing with clients, consumers, patients, what have you. And also I want to talk to you about things special to the COVID-19 era, how that's changing things for people facing the housing legal issues in New Mexico. So I will show you my screen. Let's see, where did my share screen go here? Okay, there we go. And feel free to ask a question. And I don't have my chat box up, so if anybody wants to tell me they see a question, I don't know how to share my screen and look at the chat. So if anybody sees a question, Grace, if you want to tell me there's a question, that's fine, or wait till it's done, or whatever, I don't mind. Okay,
I'll take care of that.
Okay, or people can just talk, unmute and talk if they like. All right, so so the first thing I want to talk about is the beginning of the rental process. And this is I'm coming at this from, my clients are all low income. They're less sophisticated than the average New Mexican. And often things that we might take for granted, some of my clients just don't understand or wouldn't think of, like getting things in writing, or getting receipts. So I'm going to give you folks basic information because some of your people might need it. A lot of issues result from when the person first rents a home. They don't get the home they thought they were getting, or they think they're putting money down on a home and they find out that they didn't get it. So so we tell people first, don't put any money down on a rental unless they have a written lease or something in writing that tells what the deal is. They need to know the amount of the rent, whether it's a deposit, whether it's month to month or it's supposed to last a year, and who's going to pay utilities, and the landlord's address. We have some, most landlords are happy to give you their address. They want rent. They want to be told when something's wrong, but a few won't give you their address, and that's a red flag. If a tenant pays a deposit, get a receipt. A year down the line, the tenant, the relationship's over, and the tenant says, "I want my deposit back," but then they have no proof they paid a deposit. And often it's not anything about the landlord's lying, but it could have changed property managers or ownership. And if it's a new person, they might not know that the tenant paid a deposit. So get a receipt for any money you pay. We have people who call and say, "Well, I moved out of my old place and I showed up at my new place. I'd rented a moving truck. The truck was full, and it turned out that the place was trashed. He told me he'd clean it, and he never cleaned it." Or he told me he'd give me apartment A, which was 3 bedrooms and 2 baths, which I needed for my kids. And instead, I showed up and he gave me apartment D, and apartment D is only 2 bedrooms and 1 bath, and it's upstairs, and I have a disability. And sometimes the tenants move in anyway because they're desperate. They've given this person money. They have no other place to go. And their stuff is in a truck, and they got to return the truck by midnight. So we tell people, if at all possible, if they show up and the home is not as promised, then don't move in. Rent, a tenant's main obligation is to pay the rent, and most disputes arise because of non-payment of rent. So people should always get a receipt for rent. Now, a lot of our clients pay with money orders, and there's a lot of reasons. One is you don't want to give cash. A money order can be traced, but a money order takes a month or two to trace. It costs $15 to $25 to trace. And often the money order companies, what they provide you is a scanned copy of the canceled money order, and the scanners aren't any good, and they don't show ink. So I've gotten many money orders that you can barely see that somebody signed the back of the money order, but you can't read it because the scanner is poor quality. So money orders are not perfect. Plus, you want to be able to, if you're in court, you want to be able to show immediately that you paid or you didn't pay. And a money order stub says you had the money order stub, but it doesn't tell you who you gave it to or when. So we tell people, always get a receipt. Have them sign the money order stub. Someone who won't give a receipt is not playing fair. Why wouldn't someone give a receipt for money they received? So ask for the receipt, get it. New Mexico landlord tenant law allows for the charging of a late fee, but the late fee must be written into the lease. If there's no late fee written into the lease, the landlord's not allowed to get a late fee. The late fee the late fee maximum is 10% of the monthly rent. So no matter what the lease says, a judge should look at the late fee and cap it at 10% of the total monthly rent. Now, theoretically, the tenant could be behind $1 or they could be behind $1,000, and the landlord would still be entitled to the same late fee, 10% of the monthly rent. It's not dependent on how much is owed. It's dependent on what the monthly rent is. And the late fee also has to be, the landlord has to give notice at the end of the month following the month that the rent was late. So if I pay rent late in October, the landlord has to notify me I'm going to be charged a late fee by the end of November. Otherwise, it's waived. Rent increases. If the lease says the rent is a certain amount, that's the rent for the term of the lease. At the end of the lease, or for a month-to-month tenant, the landlord has to give 30 days written notice before the next rent due date before they can increase rent or change other material terms of the lease, like who pays for utilities. A lot of disputes come up over repairs. The tenant claims that the landlord has not fixed something. So what's the first thing to do? Put it in writing. If a landlord, if a property needs the heat fixed, if it needs the swamp cooler fixed, if there's no hot water, if the ceiling is falling in, if there's a leak, always, always, always ask in writing. If the tenant asks in writing for a repair and the repair is not done in 7 days, the law sometimes lets the tenant withhold a portion of the rent. This is widely misunderstood. Some tenants believe they can withhold all of the rent because a repair is not done. That's not the rule. The rule is you can withhold 1/3 of the rent if you continue to live there, or you can withhold all of the rent if the defect is so bad that it forces you to leave. A tenant is not allowed to repair and deduct from the rent. If the repair is not done, the remedy is to put the landlord on notice in writing or file something in court, but they're not allowed to perform the repair themselves and deduct it from the rent. We always tell people to take photos. Judges don't like to decide whether the plaintiff or the defendant is telling the truth if they can just look at a photo and decide from the photo. So if there was a repair issue and it could be documented in a photo, take the photo. We tell people to call code enforcement if it's a serious issue. In Albuquerque, that's done by calling 311. You call 311, that's the city number for pretty much everything. And you ask for code enforcement. Then you get connected to code enforcement. You tell them about your issue. And they're supposed to give you an incident number and schedule an appointment to come inspect. Now, if they come inspect and they find a code violation, they put it in writing and notify the owner. And this does a couple things. One is the owner is ordered to fix the problem, and that solves the problem if the owner fixes it. Another one is if the owner's not going to fix the problem, or they're going to delay a long time, now you have something in writing from the city that says there's a problem. Again, a judge doesn't have to decide whether the landlord's telling the truth or the tenant's telling the truth. They've got this code enforcement officer who is not allied with either side, telling you that there is a problem. Outside of Albuquerque, it depends on the municipality, the county, whether there is a active code enforcement section. Bernalillo County has its own code enforcement officer who will inspect and issue violations. I don't know outside of Bernalillo and Albuquerque, but if anybody has a question about that, I can help them look. And at least in Albuquerque, if someone's violations are so severe that code enforcement tells them to get out, it might qualify them for emergency public housing from the city of, or from Albuquerque Housing Authority. I went too far. Okay, again, if anybody has any questions, feel free to interrupt because people might be getting tired of my monotone and want to hear somebody else's voice. Eviction, and this is going to be the biggest topic because most people come to me because they're being evicted. Unfortunately, if there's a problem, people wait till the last minute. So by the time they call us, they're probably going to court. The most common reasons for eviction: non-payment of rent or utilities. That's the big one. But there's other non-money issues that come up: noise, disturbances, abusive language, damage, unauthorized residents or pets, crime and drugs and fighting and alcohol. And finally, when your term ends, if you're a month-to-month tenant or your lease is up, either side can just end the relationship with 30 days written notice. And if a tenant stays on after notice is given that the relationship will be ended, then the owner can go to court. Now, there are things that a tenant cannot be evicted for. One is domestic violence incident if you were the victim. In general, if there is a DV incident, the tenant cannot be a victim. And I put maybe here because there's a lot of wrinkles. If it's subsidized housing, the tenant has a lot more protections under federal law. But even if it is not subsidized housing, the tenant has protection under state law. We advise people to go to the district court and file for a domestic violence protection order. First, because it can help protect the victim from further violence. And second, it might help you succeed in not being evicted. Another thing you can't be evicted for is requesting repairs. If you request repairs, it's unlawful for the landlord to turn around and terminate your tenancy. Now, if you've done something else that gives them the right to terminate the tenancy, that's a different matter. Calling code enforcement. If you call it code enforcement because you have no heat in the middle of winter, the owner's not allowed to terminate your tenancy. The owner is not allowed to terminate your tenancy if you're a member of a protected class, a person with disability, or because of your race, religion, gender, sexual orientation. And if the violation is a result of disability, sometimes you're protected. We have many clients who have stopped going to the doctor, stopped taking their meds, or have a traumatic incident which causes them to act out. And the manner in which they act out for someone who does not have a disability might be cause for termination. But what they did or didn't do can be directly linked to disability. And there's some assurance that it won't happen again, either because it's an isolated incident or because they've changed their medication, or they've changed their therapy, or the trigger that caused it is removed. We've had a lot of success in either keeping the person in the unit or negotiating a soft exit where they're given more time to move so that they can go to a different unit.
And Tom, we have a question regarding retaliatory eviction for calling code enforcement. How explicit does the eviction have to be for the judge to find that it's retaliatory?
Well, if the tenant calls code enforcement and the owner terminates the rental within the next 6 months, it might be classified as retaliation. And I call it might because what if the tenant also didn't pay rent? Well, it's not retaliation. The owner's going to say, I'm terminating it for non-payment of rent. And the owner's probably going to win. Or what if the tenant got in a fight with a neighbor or something like that? So if there's a separate lawful grounds for retaliation, probably the owner will be able to evict him. But what if it's a no-cause termination? In unsubsidized tenancies, the owner can terminate the relationship with 30 days notice in most circumstances, if it's a month-to-month deal or it's at the end of the lease. So if there's been a recent code enforcement call, the tenant's going to say, well, I pay my rent, I'm a good tenant, I just called code enforcement. And the tenant's going to tell the judge the only reason that they could have terminated this is because I called code enforcement. And I think it would behoove the owner to come up with a reason, a non-retaliatory reason, like, no, actually, I've terminated every tenancy in the building because I'm going to gut the building and remodel it. Or I'm moving into the unit, and some evidence of that. So I think in most cases, owners are not going to come out and say, I'm terminating you for calling code enforcement, although sometimes they do. The eviction process in New Mexico is pretty quick. It's driven by paper. I'm a lawyer. Most judges are lawyer, and lawyers love, love, love paper. So, so the eviction process is no different. It's driven by paper. So it starts with the landlord giving a written notice on a piece of paper. And it says what's gone wrong. It says, you owe me rent, and here's how much. Or it says, you haven't taken out the trash. Or it says, you had a party last night, or you were arrested for drug-related activity, or whatever the owner's complaining about. It usually gives the tenant time to fix the problem. We call it curing the problem. So with rent, you fix it by paying the rent. For disturbances, well, you don't disturb anybody anymore. For trash, you clean it up. If it's your boyfriend moved in with you and he's not on the lease, you kick out the boyfriend. And for rent, they have 3 days to cure the problem. For most other problems, it's 7 days. There's a dispute. I think it's pretty clear that 3 days, 7 days are business days, not calendar days. However, many judges apply those as calendar days, not business days, and many owners too. If I were an owner, I'd be safe and give the tenant the business days so that when I go to court, I have a cleaner case. There are some very severe violations. You don't get a right to fix it. You just have to move out in 3 days. And that would be where you committed a robbery in the premises, or you unlawfully used a weapon in the premises, you had drug-related criminal activity in the premises, some kind of crime of violence in the premises. After you have your period runs out and you haven't fixed the problem, or if it's the kind of thing where you're not allowed to fix it, you just have to move out, and you haven't moved out after the period expires. On the day following the expiration, the owner files what's called a petition for restitution, and restitution is New Mexico legalese for eviction. That's usually filed in magistrate court outside of Albuquerque. And I know we have some Albuquerque people here. In Albuquerque, it would be filed in Metropolitan Court. It can also be filed in district court, but most owners don't start out there because you need a lawyer in most cases in district court. The court is supposed to set a hearing 7 to 10 days later. Now, it could be longer, but it's usually 7 to 10 days. So that's pretty quick. 3 days to pay the rent, and if you don't, 4 days later, the owner files, and then there's a hearing a week and a half later. If a landlord wins, the court issues what's called a writ of restitution. And a writ is an order to the sheriff to remove the tenant if they're not out by a certain date. That date is 3 to 7 days after the hearing. And the judge has total discretion on whether to set it at 3, 4, 5, 6, 7 days. Some judges say, well, if they show up for court, I'm going to give them 7 days. I'll give them the full 7. Some judges want to give the 3. Some judges say, well, if there's elderly people, disabled people, or kids in the premises, I'm going to give the 7. In Albuquerque, 7 days is 7 calendar days. In Sandoval County, 7 days is 7 business days. So it depends from county to county, judge to judge. If the tenant is not out on the final day, the day after, the landlord can contact the sheriff and say, can you help me evict them? In some counties, in the more rural counties, it happens on that day. The sheriff goes out that day and evicts them. In Albuquerque, generally it takes the sheriff a week to get out there. When the sheriff shows up, she meets the owner there. and the owner's supposed to bring a locksmith. The sheriff generally tells the tenant, I'm sorry, I have an eviction order here, you have to get out. My understanding is the sheriff gives the tenant a minimum amount of time to grab some stuff. If you have a client in this situation, we always tell them, pack a suitcase, get your most important papers, your medications, your valuables, your family heirlooms, your toiletries, change of clothes, underwear, stuff for your kids, your kids' school stuff, your computers. Put all that by the door because the sheriff's not going to give you an hour to gather your stuff. She's going to have more important things to do, and she's going to want to get out of there. So we tell them to do that. And we don't guarantee when the sheriff's going to be out there. The sheriff could be out there the day of, or it could be a week. After the judge issues the order saying you have to get out, the tenant might choose to just move if they can. If they can't move, many people just stay to the very last day because they figure, well, I want to stay out of the shelter as long as possible, so I'll wait it out. If the tenant appeals before the eviction happens, that automatically stops the eviction. The tenant files the appeal in district court. An appeal costs, I believe, $130 and change, but most of our clients qualify for what's called indigency, where the judge or the court will waive the filing fee because they're low income. They have to fill out an affidavit saying what their income is, what their family composition is, whether they get any public benefits, and then they can have the filing fee waived. And once they file, they need to take a copy of that appeal back to the trial court, the magistrate or metropolitan court, and give a copy immediately to the owner, and that automatically stops the eviction. There's one catch. The tenant has to pay the rent that comes due after the appeal. They don't have to pay the rent that is part of the judgment because that's in dispute. But if they're going to take advantage of this stay of the eviction, they have to pay the post-judgment rent. And there's kind of a process for that if any of you have any questions, I can explain to you. If they're evicted, go ahead.
Actually, so we have a couple questions. So Juan had a question, does immigration status affect the eviction process?
It's not supposed to be, not supposed to affect eviction process. Now, New Mexico Legal Aid, which is federally funded in part, about half of our funding comes from Washington, D.C., generally cannot assist undocumented clients, with some exceptions, including clients who are DV victims. There are other organizations that might be able to help them. That should not affect the eviction case itself, but it affects their ability to get counsel.
Thanks. And then we had another question. Once the sheriff kicks the tenant out, what happens to the rest of the tenant's belongings that they weren't able to take in that time period?
They have 3 days to get their stuff. And it's not starting, you don't count the day that you're evicted, you count the next 3 days. So they have until the end of the next 3 days to get their stuff. Again, that is business days, although many landlords might just give you 3 calendar days. It's tough because, first of all, if they don't have the resources to pay their rent, they might not have the resources to get a truck and get some bodies to help them move, to find a place to put their stuff. And a lot of people, frankly, just grab their valuables and walk away and start over, which is really traumatic because their stuff might not be much, but it might cost thousands and thousands of dollars to replace. So we tell people to do the best they can. They should notify the landlord immediately in writing so they can document it that they want to come by and get their stuff immediately. And then the owner should set a time. And it shouldn't be an hour or a half hour. The law doesn't say how much time the owner has to give them at a certain time, but I think they should have the whole 3 days but it depends on the size of the property. If it's a 4-bedroom home, it's going to take longer to move than if it's a studio or a room in a boarding house. So the amount of time they need is what is reasonable. We tell people if they're having disputes over the owner not giving them access to the property, put it in writing, I'm coming to get my stuff. And as a last resort, as soon as possible, however, file a resident petition for relief in magistrate or metropolitan court. I've never dealt with this issue in any magistrate courts, but in metropolitan court, the judges will just want to get the problem solved. They'll say, okay, owner, are you available today? Okay, tenant, you available today? How about you guys meet at 3 o'clock? How much time do you need, tenant? Well, I need 8 hours. Okay, why don't you meet at 8 a.m. tomorrow? They try to work it out, get the problem resolved, because the tenant needs their stuff. And the owner needs to get rid of it because they want to clean up the place and rent it to the next person so they can make some money and pay their mortgage. So it's in everybody's interest that this stuff gets taken. In New Mexico, a landlord does not have a lien on the tenant's personal property. They don't get to say, you didn't pay the rent, you owe me $1,000, therefore I'm keeping your nice bed and your TV. They're not allowed to say that. That is illegal. So we hope that owners will let the tenants get their stuff, and we hope that tenants will make arrangements that they can get the stuff, and that usually involves a truck and some bodies and a place to put the stuff. Any other questions? If you're not evicted, if you're moving out for other reasons, the law gives you more time. If you're moving out just because it's the end of the term, the law gives you 14 days to get your stuff, not 3. And 14 days is definitely calendar days because it's a longer period. If you abandon the premises, if you just move out without telling anybody, without paying rent, without telling the landlord, there's a process that the landlord has to give you written notice of 30 days that they intend to dispose of your stuff in 30 days. In New Mexico, an owner is not allowed to use self-help eviction. They need a court order to evict someone forcibly. They can't change the locks or remove the locks. They can't turn off the utilities. They can't send their weightlifter brother to scare the tenant into moving out. They can't threaten to do these things. The law strictly forbids this. If it happens, we advise tenants to call the police. Police generally don't get involved in civil matters, but often they will write a police report documenting what happened. And sometimes they will speak with the owner and say, come on, I need to keep the peace here. This is a disturbance of the peace by locking this person out or turning off their gas. They got kids. Fix the problem and do it the right way. Go to magistrate court or metro court and evict them. And then we tell tenants to file an action for possession in magistrate or metropolitan court. The court is required to set a hearing in 3 to 5 days. And if the court finds that the landlord illegally locked out the tenant, the court is supposed to restore possession to the landlord with the sheriff's assistance if necessary. Damage deposits. Most owners charge damage deposits. That's meant to cover damages, cleaning, unpaid rent, and utilities when the tenant moves out. When the tenant moves out, the owner is required to give notice within 30 days of the reasons why they withheld any portion of the damage deposit plus a refund of the balance. If they don't send this list and the deposit balance within 30 days, they lose the right to keep the deposit for any repairs or damages or cleaning, and they lose the right to sue the tenant for damages. It's a little more complicated than that, but that's the basic rule. We tell tenants when they move out, give a forwarding address. The landlord doesn't have to send you your money if they don't know where to send it. So give them a forwarding address and some kind of proof of how you did it. So, write a letter. I moved out. I returned the key on October 31st. My forwarding address is care of my mom, 123 Main Street, Roswell, New Mexico. Keep a copy of that letter to prove that they gave this notice. In Albuquerque, There are a lot of people living in motel rooms on long-term rentals. And it's often people who can't come up with a damage deposit, or who have bad credit histories, or have criminal histories that make them unable to get traditional apartments or rental homes. Motel residents have rights as tenants sometimes. And that's good because it can't be evicted without a court order is the big one. So when is a motel resident a tenant under Albuquerque or under New Mexico landlord tenant law? It's when they pay rent weekly or less often. So it could be bi-weekly or monthly. And they intend for the motel room to be their home. And that's usually when that's their only place to live. So why that's important is it's meant to exclude people who come here for vacation. So if a person does not have any other home, this is their only home, and they pay rent weekly or usually monthly, they are a tenant. A lot of the motels have electronic locks, and when someone doesn't pay, they just change the code, and the tenant loses access to her room. And so these landlord-tenant protections are really important. Yeah, at New Mexico Legal Aid, we try to focus on subsidized housing. And the reason is, or one of the reasons is, if you get evicted from subsidized housing, you're often banned from the program for up to 5 years. And also the waiting list for these programs are often closed or very long. So these are the ones we focus on. Also, subsidized housing law, federal subsidized housing law is a lot more protective. There's a lot more rules that help our clients. So we're more successful in these cases. So that's another reason why we take these cases. So as a lot of you know, in subsidized housing, tenant usually pays rent that is 30% of their monthly adjusted income. So whether it's a public housing where a housing authority owns, operates the premises as the tenant's landlord, or it's Section 8 where the tenant lives in private housing, but a housing authority helps pay the rent, or it's project-based housing where HUD gives money to a private housing operator who runs the show. The tenants usually are paying rent at 30% of the monthly income. Most adverse actions by subsidized housing providers give the tenant a right to an informal grievance meeting or hearing. So we always tell people if the deadline hasn't passed, ask for that meeting or that hearing, because it often means that the landlord can't evict you until the hearing's over. And sometimes the problem is resolved at the hearing or the meeting. The parties come to an agreement. You don't have to go to court. And even if it's not resolved, the tenant usually still gets the right to be taken to court so they can have their dispute decided by a judge. If a tenant winds up in court and it's a rent dispute, judges often cut these tenants some slack and are allowed to be flexible and give the tenant a payment plan to pay off any amounts owed instead of just evicting. If a tenant in unsubsidized housing goes to court over a rent dispute and the judge finds the tenant owes the rent, then the tenant gets evicted, almost always. But in subsidized housing, the tenant often is given a second chance. A key thing in subsidized housing is the tenant is not liable for the housing authority's portion or HUD's portion. Some rent disputes arise because the housing authority stops paying. Often the housing authority stops paying because the landlord did something wrong. Well, that is a dispute between the housing authority and the landlord. The tenant can't get evicted for that. There's another big program in New Mexico. It's called the Low Income Housing Tax Credit. And so a lot of the newer buildings In order to raise money to build the building or to rehab the building, the developer competes with other prospective developers to submit applications for tax credits. And if the developer's project is selected, tax credits are awarded to the developer. The developer sells these huge tax credits to rich people who pay the developer, and the developer just uses the proceeds of the sales of the tax credits to fix the building or build the building. There are some strings attached to this program. The developer is not allowed to evict tenants except for good cause. Now, in non-subsidized housing, a tenant can be evicted at the end of the term with 30 days notice. But in tax credit housing, the tenant has a lease for the life of the program, which is usually 33 years. They can't get evicted unless they do something wrong. Another key provision is tax credit landlords must accept Section 8 vouchers. A non-subsidized landlord in New Mexico generally is not required to accept a Section 8 voucher, but tax credit landlords are. And finally, a tax credit landlord must accept the rent offered by a housing authority for the Section 8 tenant. The tax credit landlord says, no, I'm not going to take you. Albuquerque Housing says they'll only pay $900 for this unit, but we're charging $1,000. No, they have to take the rent offered by the housing authority. Other issues that come up with our clients are real estate contracts and rent-to-own deals, which for low-income people very, very often go bad. Mobile home disputes. We take a lot of mobile home cases. There's a special law called the Mobile Home Park Act, and it applies to people who own their mobile homes but rent the space that the home's sitting on, and where the mobile home park has 12 or more of these spaces. These folks get special protection because most low-income people, if evicted from a mobile home park, cannot afford to move the home that they own, and they walk away from it and they lose their only investment. The law gives them special protections, and we represent people in these cases. Another big area of housing subsidies in New Mexico is supportive housing. Supportive housing is a group of programs generally funded by HUD, and they work often like Section 8 housing, where the tenant is given a voucher. The voucher is administered by a nonprofit agency. Along with the housing comes case management, because these programs are generally for people with disabilities and people with a history of homelessness who are historically hard to house. They take those vouchers and rent from private landlords, and disputes arise, and we represent people in these kinds of cases. They work like Section 8 housing often, but the provider is given more leeway on whether to terminate people when the tenant does something that's in violation of the program, because these folks are hard to house, and they have disabilities and they have histories that make them more likely to become homeless. The agency gets a lot more discretion in terminating folks. Any questions so far before I move to COVID-19? Okay, so during COVID-19, a lot of people lost their income, and it made it harder to pay rent. In a recent report by the National Coalition of State Housing Associations, of which our Mortgage Finance Authority is a member, they found that 60 to 80,000 New Mexican families right now are unable to pay rent, and they're at risk for eviction. They predicted there would be 50,000 eviction filings in New Mexico by January, and that would involve a rent shortfall of over $100 million, which actually doesn't seem like that much money by federal budget standards. And you can find this report. I put a link there. Our state and federal governments have taken some action to try to prevent people from becoming homeless since the pandemic started. One of them was the CARES Act eviction moratorium. And the CARES Act was a big federal bill that had a lot of stuff in it to respond to coronavirus. But one of the things was an eviction moratorium that applied to subsidized landlords and to landlords with federally backed mortgages. That moratorium ended in July. However, there's at least one key provision that remains, and that landlords who were covered by the CARES Act must still give 30 days written notice before they file for eviction for non-payment. You might recall under state law, it's 3 days notice, but under the CARES Act, it's going to be 30 days. The next big one is our Supreme Court, our New Mexico Supreme Court, issued a stay on certain evictions. And so the stay is on writs of restitution. And remember, that's that final order by the judge telling the sheriff to evict the family. If a writ of restitution is issued for non-payment in a residential landlord-tenant case, which includes mobile home park cases, the judge is supposed to assess whether the tenant is currently unable to pay the rent. If the tenant is currently unable to pay the rent, the judge is supposed to stay the writ of restitution. So there's a judgment issued. It says, tenant, you owe the money and you're going to be evicted, but it's not going to happen now. Before COVID, the judge evicts the person in 3 to 7 days, but now it's just temporarily put on hold. Currently unable to pay rent does not have to be related to COVID. It could be related to some other problem. They could have lost their job unrelated to COVID. They could have lost their benefits unrelated to COVID. It might be related to COVID, it might not be. The tenant has to show up for court. They have to be there to tell the judge, I'm currently unable to pay the rent. The judge doesn't have any evidence to find that if the tenant isn't there to tell the judge that they're currently unable, and tell them why so they can give the judge grounds for believing it. We don't know when the stay will be lifted. Our belief is the Supreme Court is following the orders, following what the governor's doing. The original stays came down after the judge, or after the governor issued her stay-at-home orders, and so the Supreme Court is sort of following what the governor's doing, what's happening in the pandemic. And one day we'll lift the stay. And when that happens, we're not sure what's going to happen because all these people have judgments for restitution. And now the writ of restitution is not stayed. And the sheriff could show up and evict these, thousands of families. So we're hoping that the Supreme Court will be able to give some guidance and perhaps some cushion for people who are in this situation, and maybe some mechanism for the people to redeem their tenancies by paying what's owed. At the beginning of September, the Centers for Disease Control issued its own eviction moratorium. This applies to all landlord-tenant, residential landlord-tenant relationships in the country. It was effective September 4th and it lasts till New Year's Eve. It was enacted as a public health measure. The CDC made extensive findings on how eviction increases community spread. If people are required to shelter in place in their homes, and they can't do that if they don't have homes. If they have to go to shelters, they'll be in closed spaces with other people. If they become homeless and on the street, they'll be interacting with other people. Or if they have to move in with family, private homes will become more densely occupied. So the CDC found as that eviction should be stopped stopped as a public health measure for you and for me to prevent the spread of COVID-19. So what it does is it prohibits landlords from taking any action to remove or cause the removal of tenants for non-payment of rent or other charges. So it only affects money evictions. It doesn't affect the person who's being evicted for conduct. And it's a really broad ban. Any action to cause the removal of tenants, that would be a notice saying get out, pay or get out. It would be filing a lawsuit to evict someone. It would be going to court saying, judge, evict this person. After court, it would be going to the sheriff and saying, I've got this writ of restitution, please serve it on the tenant. It would include meeting the sheriff at the premises to evict the person. To invoke the CDC protections, the tenant has to fill out a declaration, and it's under penalty of perjury. So they're not allowed to lie. I've put a link to the declaration, a fillable form on New Mexico Legal Aid's website. And the declaration requires the tenant to swear to 5 or 6 things, and they have to do with they're not able to pay rent. They've made best efforts to pay as much as they can. The inability to pay rent is due to loss of job or some other things. And it doesn't have to be COVID related. And that they've made best efforts to apply to government authorities for rent assistance. That might be to apply for Section 8, which is generally going to be unsuccessful because most Section 8 waiting lists are long or closed. It could be applying for rent assistance from, say, the city of Albuquerque, which has a rent assistance program. The tenant then serves the declaration on the landlord, and the landlord is forbidden from taking action to evict the tenant. There's really severe criminal penalties, $500,000 up to $500,000 and 1 year in prison for a landlord who violates this order. I haven't seen the U.S. attorney take up any criminal cases against landlords for violating. I guess it's possible. They might feel like they have more important things to do. I'm not sure. There is some dispute as to whether the CDC order applies in New Mexico. I think it's pretty obvious that it does, but we haven't gotten any guidance from the courts on whether it does or doesn't.
And Tom, we have another question. How do constructive evictions relate to the COVID crisis?
Constructive eviction is if the person's saying it like I would understand it, is when the landlord takes some kind of action that's not filing in court or turning off the lights or telling the person to get out, which has the effect of getting rid of the person. Like, what would it be? Building, I don't know, something to make the tenants, the place uninhabitable. So I'm not really sure what they're asking. You know, not fixing the heat could be called, or not fixing the swamp cooler, or not fixing a broken door could be called a constructive eviction.
Yeah, and so she clarified in the chat. So for example, if the landlord doesn't fix a problem,
Okay,
and
so
that causes a family to move during COVID.
okay, so if a landlord doesn't fix a problem, I think that you would say that's not a COVID issue. That's a state landlord-tenant law issue. The tenant would first give the landlord written notice, fix the problem. And if they use the notice provided by the Supreme Court on the court website, it says what their remedies are. They can either withhold a portion of the rent, that's called abatement. And that's supposed to get the landlord to incentivize the landlord to fix the problem, or they can terminate the tenancy, or they could go to court and ask the judge to order the landlord to fix the problem. So I think that's their remedies. Of course, I can see a landlord saying, well, I know I can't evict this person because of COVID, but um, I'm gonna get rid of them by not fixing things. But I haven't seen that issue come out. Anybody else have questions? Um, Ever since, I believe it's since March, the courts have had special provisions in place to reduce the chance of people becoming infected because of their involvement in the court process. So normally the way people file court paperwork is you go to the courthouse to the clerk's office and file it there. But now the court is allowing fax filing and email filing. All the courts are. And they're also requiring people to appear by telephone or video. So instead of going to court for a hearing, you call in. There are exceptions. I've appeared, I think, for one or two in-person hearings because there were complicated facts and the judge wanted to look the parties in the eye and see who was telling the truth. But the vast majority of these cases are heard by telephone or video. And video is Google Meet, usually. There are problems with this. On the one hand, people who might have trouble getting to the courthouse because of childcare issues or because of disability or because of just fright might not have that problem because they can appear by telephone. But we have people with disabilities who have trouble participating electronically. We have people with limited minutes. They have no phone at all, or they have poor cell service who might have trouble. We have people who are cut off during their call. We have people who are generally just technophobes. They're just not comfortable dealing with the phone. Of course, if you're on a telephone, it's hard to show paperwork to a judge. So the way that's overcome is if you're on a video call, perhaps you can show it on the screen, or perhaps the judge will say, here's the email address. Can you take a picture of it or scan it and email me that paper? And we'll look at it right now, or we'll reset this till tomorrow or next week to look at it. I know with Metropolitan Court, if you telephone in, there's a mute and unmute button, which is kind of complicated because mute and unmute is explained in a long, long message. And when the judge gets on, she knows that's a problem. So she'll remind people, hey, if you need to talk, you need to unmute, and here's how you do it. I think it's *6. But that has been a problem where people aren't able to participate because they have trouble figuring out the mute and unmute. So there's pros and cons to this. And I think lawyers are getting used to it. For me, it allows me to call into a case in Silver City or Roswell or Clovis. I don't have to travel hours to get there. And so in Albuquerque, we're a lot more likely to take a case that's outside of the Albuquerque area because of the telephonic or video hearings. So there's pros and cons to this.
And Tom, we had another question in the chat. So someone who's had a landlord come in and state that they're not able to pay the gas bill because the renter isn't paying rent and the landlord is short on money as well. So what options or resources do you know of that might be available to landlords?
That's tough. I think they would probably be rent assistance options for the tenant, because if the tenant can get money to pay the landlord gets paid. A lot of rent assistance is not given to the tenant directly because they want to make sure that the money goes to the landlord. So a check is written to the landlord. In your area, you might have your usual suspects of charitable organizations that give rent assistance. Also, there there's the option in the city of Albuquerque of calling 311 and asking for rent assistance. And I don't know about options in outside of Albuquerque. Go ahead.
Okay. I was going to say the other thing I will say is that I know If for some reason rent assistance isn't an option, if it is specific to utilities, utility companies will sometimes work with people also. I know they were putting out information that they were willing to work with people who'd been impacted by COVID. So that might be another option.
It always behooves the parties to talk. If it's a rent issue, the landlord might have trouble evicting the tenant because of the Supreme Court stay. And I was in court yesterday with a judge, and she told the landlord, I know that you want to get rid of her, but I might have trouble evicting her because of the Supreme Court stay. And she's offering to move out, but she needs a little more time to find a place to use her voucher with. So you're actually better off waiting a little longer than to have me make a decision today, because I might not evict her because of the Supreme Court stay. So what I'm saying is things, it often works for both parties if they can talk and work things out. So maybe there's some kind of compromise. You know, the tenant needs to go and apply for rent assistance so they can get some money to the landlord, and the landlord can put the utilities back on. Maybe they can change their agreement so that the tenant is now responsible for utilities. And in return, the landlord will let them stay a little longer without going to court and putting the dispute in the judge's hands. Maybe the tenant needs to file in court and ask the judge to order the landlord to put the utilities back on. I'm not sure. It depends on the circumstance.
So we have a couple questions about subsidized housing. So our subsidized, so in first, a lot of, we had a comment, a lot of community centers are helping with utility assistance, and so are local churches, right? And also, I know some of the community foundations around the state are also helping with rent assistance too. So if there's a community foundation in your area, that might be another place that people can go for help. So thanks for that information. And so with regard to subsidized landlords, the first question, did you say that subsidized landlords can evict without cause once a rental period is up?
If they are tenant-based Section 8, yes. So that's the traditional Section 8 voucher, where it's a three-way relationship between a housing authority, a private landlord, and a tenant. When the term is up, the landlord can evict with 30 days notice. Or the tenant can choose to end the relationship with 30 days notice. That is Section 8 vouchers. Now, if it is a different kind of landlord, let's say it's a HUD multifamily landlord, a complex that's getting money from HUD, there's no housing authority usually involved. Those tenants get to stay for life as long as the property is in the HUD program. These are often Section 8 programs. It's a different kind of Section 8 program, but those kind of landlords cannot evict except for cause. Tax credit landlords cannot evict except for cause. Now, what is the rationale here? Well, if a tenant with a Section 8 voucher doesn't lose their subsidy when they move, they can take it to another landlord and continue with a roof over their head and their subsidy. But if you live in a HUD complex, the subsidy doesn't follow the tenant, the subsidy follows the complex. So if the tenant's evicted, they lose their subsidy and they could be homeless. So they cannot be evicted except for cause.
And then the second question, are subsidized landlords now able to evict for non-payment of rent, even if the inability is due to COVID?
The CARES Act does not apply anymore. That's over. So they can, but they have to give 30 days written notice instead of 3 days. Also, they run into the Supreme Court stay, which if the tenant has not paid their rent and they're currently unable to pay the rent, then the judge is supposed to stay the eviction. And, you know, with subsidized, with HUD subsidized and USDA subsidized rentals, the rent floats with the tenant's income. So theoretically, a tenant is never currently unable to pay because if they lose their income, the rent drops. The problem there is there's a delay between the rent dropping, between the tenant losing their income and the rent dropping. They have to notify, the tenant has to notify the landlord immediately that they lost their income. And then the landlord will reset the rent in the next rental period. But because of delays, it often means that the tenant has at least one payment they can't afford. Also, there's family tragedies where a tenant has to pay for a funeral or has some kind of medical bill that wasn't covered by their insurance. Or a big one is the car repair. The tenant works and their car broke down and they have to pay $1,500 to fix the problem. And now they have no rent money. Now their income didn't drop, so they're not eligible for a change in rent, but they have no money. And even before the COVID era, New Mexico law gave judges the discretion to put tenants on payment plans instead of evicting them. And I hope, especially during the COVID era, that's what a judge would do, where a subsidized tenant shows up and has not paid rent. They don't dispute that they haven't paid rent, but they have a good reason. And that way, if they can pay over time, the landlord gets paid, the tenant keeps their home. We don't have homeless people in the streets.
Thanks. And so I also want to make sure before we go on, the Taos Community Foundation let us know in the chat that they are helping through nonprofit organizations with sub-assistance, but not directly to individuals. So thanks for sharing that also.
We tell people you still have to go to court. No, court is telephonic or it's video, but you still have to show up. Some people are under the mistaken impression that they can't be evicted because of the CARES Act or because of the Supreme Court stay, and that's not true. They still have to show up to court. If a person doesn't show up for court, they're probably going to be evicted, no matter how good their defenses are. We tell people if it applies, if the CDC order applies to you, meaning it's a non-payment situation, and you read that declaration and all the things in that declaration are true, sign it, give it to the landlord, and file it with the court to let the judge know that you did it. Now, under the terms of the order, you don't have to show up. If a judge knows you filed the CDC declaration, the judge, my reading of the law, should stop things and dismiss the case. But I don't know that that's going to happen. So we tell everybody to show up to court. At the hearing, the tenant needs to tell the judge about the CDC declaration. They need to tell the tenant whether they're subsidized. They need to tell the judge they are currently unable to pay the rent. That's the magic words for the Supreme Court stay. If they filed a CDC declaration, they should ask the judge to dismiss the case. The dismissal would be what we call without prejudice, probably, meaning that the owner can come back and evict when the moratorium's over. And if the CDC order doesn't apply, they should ask the judge to apply the Supreme Court stay and stay the eviction until COVID's over. They should ask the judge for a payment plan. Hopefully all the owner really wants is to get paid. So if the tenant can pay the owner over time, that might resolve the issue. In general, we always remind tenants to get receipts. We tell them to put everything in writing, including requests for repairs. Take pictures. When they move out, clean the home and take pictures. When they move out, give the keys to the landlord. A lot of judges will say it's the tenant's apartment until they turn over the keys, and they will be assessed rent until the keys are returned. So return the keys as soon as possible, get a receipt for them. Give the landlord written notice of the address they're moving to so that they can send the damage deposit. Forward the mail at the post office. Here's some resources. New Mexico Legal Aid has a toll-free statewide intake number. And if someone calls that number, they can get free advice. They might get representation. They might get help preparing forms in a wide range of civil services, civil areas. There's a link to our renter's guide. It's a 80 or 90 page booklet now online that has a simplified explanation of New Mexico landlord tenant law. And we sometimes advise tenants to call the police in emergency situations. Police might not get involved, but they can document what happened. And they might mediate and get the people to act right until a civil court can get involved. Any questions?
So Tom, I have I guess a question and something that's confusing for a lot of the people that I talk to. So there's all the CDC moratorium and our state Supreme Court order, and probably one or the other applies. But does this mean that landlords can never evict tenants? For example, if a tenant commits a crime on the property, or there's some non-rent-based violation of the lease?
That it doesn't mean that at all. So if it's a non-money issue, it's clear under both the CDC and the Supreme Court orders, and even the former CARES Act, those laws didn't apply to non-money issues. There might be some gray area if it's a money issue that's not rent. It's clear under the CDC order and the former CARES Act that non-payment, the non-payment they applied to was non-payment of rent or other charges. It's not so clear under the Supreme Court order. So in reality, most landlords will characterize all, in the lease, will characterize all charges as rent. They'll have a definition that everything that the tenant owes the landlord is classified as rent. So I think by the terms of the lease, it's clear that the lease brings that kind of case for non-payment of other charges into the Supreme Court stay. But if the tenant has committed an act of violence, has disturbed other tenants, and or done some other kind of non-money issue, a non-money violation, and the landlord follows state law on how to enforce those violations, then it's pretty clear that these things don't apply. Another gray area is termination of the tenancy at the end of the lease. Now we have in Albuquerque at least one large property owner who goes to court to evict for non-payment. The Metropolitan Court says, yeah, they owe the rent, but I'm going to stay the eviction or stay the writ of restitution because it's a non-payment issue. And then the owner then gives the tenant a 30-day notice to end the month-to-month relationship, which I see as violating the Supreme Court stay. But some judges say, well, that's okay, and we'll evict the tenant, and the owner's able to get around the Supreme Court stay that way.
Thanks, Tom. Other questions that people have? All right, we'll give everyone a few more minutes. Oh, so we have one more. Are there any resources we can share with the community at large to educate and inform? So Tom mentioned the Legal Aid Landlord Renters Guide. Legal Aid also has a lot of good information on their website about the various moratoriums. And so that's a good resource. I will send the recording link from this webinar and the presentation materials out to everyone after the webinar as well. And so you can share those with your communities. And then, you know, if you want other information or if there's a specific question, Tom shared his contact information in the chat. I'll also put my contact information in the chat, and I'm the one who's been sending you all the emails with the links to this webinar, the information. So most of you have my email, but I'll also put my information in the chat here. We have a question about places like Taos that don't have their own code enforcement. In those places, is there anything that can be done about habitually negligent landlords? So people who are renting multiple properties that are in disrepair, not giving back deposits, those kinds of things.
Besides calling New Mexico Legal Aid, sometimes we get involved in these kinds of cases. They could try calling the New Mexico Attorney General's office. Now, historically, they have not been too involved in landlord-tenant housing issues. They've shown a little more interest. I know that in the past couple of years, they've gotten involved with real estate contract fraud, which is a little more like landlord-tenant. So you can try filing a complaint with the New Mexico AG's office, and if they get enough complaints, maybe something could be done. If the owner is subsidized or has tax credits, you can try calling the New Mexico Mortgage Finance Authority, which is the conduit for tax credits and HUD subsidies in New Mexico. They also have not been very aggressive in this area, but I think if they get enough complaints about a landlord, maybe they will act. If the tenant has a Section 8 voucher in Taos, they should notify Northern Regional Housing Authority and ask for inspection. The Housing Authority, if they find a violation, can order the landlord to fix the problem. And if the problem's not fixed, they can withhold rent and eventually terminate the relationship. But that's just a tenant by tenant thing, and it's probably not going to fix the problem for everyone. Unfortunately, it's not a perfect world. One landlord, a big landlord in Albuquerque, who we heard had a lot of complaints against, and I have a colleague who took a lot of cases against this landlord. The banks took over the property, and everyone lost their home because it was condemned by the city. And the banks, the court appointed the bank as a receiver of the property because it was poorly run. And that landlord's gone, which is a good thing. But unfortunately, all these folks lost their home.
Thanks. And then another question, are there any limitations on how much the amount of rent can be increased in a renewal of a rental contract?
In unsubsidized housing, no. The owner needs to give the tenant 30 days notice of the increase, and the tenant's responses are just continuing to live there and pay the higher rent, or moving out, or negotiating with the landlord for some middle ground. Unless it's retaliation. If the tenant in the last 6 months reported to code enforcement, requested repairs, complained to HUD about discrimination or some other things, the owner probably cannot increase the rent during that 6 months.
Thanks so much. So if there are any last minute questions, we'll go ahead and give everyone a minute to put those in the chat box. Tom, thanks so much for your presentation and all of the information and resources you shared. And thanks to other people for sharing information about resources in your communities. Also, if you have resources that you would like me to share with others, please let me know. Again, my contact information is in the chat box. So I can get that information out to our various community lists. We have, we work with community organizations, specifically in Taos, Las Cruces, and Hobbs, but also can send out information around the state through some of our networks as well. So if you have information that is specific to a particular community that you'd like me to also put out, please let me know. I'm not seeing any more questions in the chat. So thank you all for coming and for all of your questions and interest in this really important area. Thank you again to Tom and also to Juana Beta for organizing these webinars. We will continue to have webinars. We don't have a date for our next one set yet, but as soon as we do, I will send that information out. And also, if there are additional topics you would like us to organize webinars about, please let me know also. Thank you so much, everyone. Take care and please be safe.
You're welcome, and thanks.